extreme right, assisted by my sister Mukami Diga, here on my right. On my left, my brother Titus Akitonga, and my sister Nasanga Aki. The petitioner has 20 minutes for their case. You have the option of reserving 5 minutes for the rebuttals. The respondents also have 20 minutes for the case. You can get the petitioner away.
Good morning, Your Honors. May it please this court, I'm Quinta Acheng Otieno, counsel for the petitioner. My co-counsel is Kithinji Kizi Doreen. We shall be canvassing the 3 grounds before this court for determination. The first ground being whether the action by the Nadian state actors to quell the protests was in violation of the Constitution and international human rights law, which shall be canvassed by my co-counsel Kizi. The second ground, which we have subdivided into 2, the first bit being whether there was excessive use of force resulting into the death of Chandra and her brother. The same shall equally be canvassed by my co-counsel Kizi. And the second bit of the second ground, which is the failure of the state to conclude investigations, which I shall proceed to canvass. And the third ground for determination on the enforced disappearance of Mumbeya and Whelan, and whether the court can issue an order of habeas corpus in regards to the same, which I shall equally canvass. We'll be relying on the Constitution of Nadia, the various statutes applicable, international laws ratified by Nadia, and case laws. We intend to use 8 minutes each, and we reserve 4 minutes for rebuttals. Unless the bench directs otherwise, I'd like to proceed to my submissions. Thank you. Your Honor, the jurisdiction of this court indeed is applicable to the facts in issue, pursuant to Article 23 of the Constitution, as read together with Article 165(3)(b) of the Constitution, that gives the High Court jurisdiction to listen to matters of violation and infringement of human rights. It is equally our submission as the petitioners that indeed we have a standing before this court, pursuant to Article 22 of the Constitution, which provides that any person can institute proceedings on behalf of another for infringement of their rights, and pursuant to Article 59 of the Constitution, that enables the Nadian Human Rights Commission to pursue mechanisms for redress in cases of violations of human rights. Without further ado, I would like to first of all begin with the third ground before this court, the issue of enforced disappearance of Mumbeya and Whelan, and whether this court can issue an order of habeas corpus in regards of the same. Your Honor, it is our submission that indeed there was enforced disappearance of Mumbeya and Whelan, and we shall proceed to stipulate the elements of the same. Article 2 of the International Convention for protection of all persons against enforced disappearance expressly defines enforced disappearance as the arrest, detention, or deprivation of liberty of an individual by the state or the state actors, followed by a refusal to acknowledge the same and a concealment of the whereabouts. It is a submission that the elements of enforced disappearance have indeed been brought out in this particular case. Your Honor, as regards the case of Whelan, pursuant to paragraph 20 of the fact sheet, we have been told Whelan was arrested by the police officers. Your Honor, Article 21 of the International Convention on Protection of All Persons Against Enforced Disappearance expressly provides that wherever a person deprived of liberty has been released, the same should be done in a manner verifiable. Your Honor, in this particular instance, there are no records pursuant to paragraph 20 indicating that Whelan was released. It therefore simply follows he was arrested by the police officers. There are no records for his release. It simply follows that indeed there was enforced disappearance of Whelan. Your Honor, as regards Mumbeya, it is worth noting that Mumbeya went to report to the police station, and later on nothing is heard of him, pursuant to paragraph 18 of the fact sheet. Your Honor, it is our submission that in this regard, pursuant to paragraph 8 of the fact sheet, pursuant to paragraph 17 of the fact sheet, Mumbeya had been receiving warnings in Mumbeya Tongo police station, and then Paragraph 21 expressly provides that Nadia has been on the UN watch list on matters of enforced disappearance. Now, Your Honor, pursuant to Section 9 of the Nadian Evidence Act, explanatory facts that rather explain or introduce a fact in issue are relevant. Indeed, the records didn't show that he was booked there. However, Your Honor, it is worth noting that all these factors point towards him being booked there. And it is our submission as the petitioners that the absence of the records was an element satisfying the fact that the state concealed his whereabouts. It is therefore our submission, Your Honor, that indeed there was enforced disappearance of Mumbaya, and that the absence of those records was just a mere conciliation of the whereabouts of Mumbaya. Your Honor, the right to an order of habeas corpus, rather. Your Honor, further to that, Article 23 of the Constitution of Nadia empowers the High Court of Nadia to issue an appropriate relief where there has been a violation of human rights. Now, Your Honor, pursuant to paragraph 154 of the Velasquez-Rodriguez versus Honduras, a 1988 decision of the Inter-American Court of Human Rights, hence persuasive in this regard, the court stated that enforced disappearance deprives the victim of his right to liberty. Therefore, Article 29 of the Constitution that provides for the right to liberty in this case has been violated, which is why it is stating that the court can issue an appropriate remedy in that regard. Your Honor, Section 389 of the Criminal Procedure Code, Cap 75 Laws of Murder, provides that the High Court can issue an order of habeas corpus for the production of an individual before the court. Your Honor, it is our submission in this regard that indeed, having established that his disappearance was effected by the state, it therefore simply follows that this honorable court can issue an order compelling the Inspector General to produce Mumbaya before the court to answer defense. Your Honor, I was equally supposed to canvass the second bit of the second ground.
Counsel, you have quoted the case of Velasquez Rodriguez. Do you wish to appraise the court of the facts of the case?
Thank you for your question, Your Honor. I apologize for not having appraised the court of the facts previously. In that particular case, Your Honor, Velasquez Rodriguez was a student at the university in Honduras, and his enforced disappearance, and the state considered him to be partaking activities which were a threat to national security, after which his disappearance was effected. Now, the same issue was brought before the Inter-American Court of Human Rights, where the court conclusively considered the issue of enforced disappearance.
Or do you wish the court to place reliance on the Inter-American Court?
Counsel, just clarification. Are you conversant with the provisions of Article 51(2) on the order of habeas corpus?
Indeed.
And if I'm correct in that manner, then it says that the habeas corpus writ can only be gotten when a person is under detention or in the custody of the police service or the investigating authority. So you want us to be of the view that even when it has not been established that that person is within the custody as of how that can be proved, but we still go ahead and give the habeas corpus writ. So how do you expect us to, how would you have the production authority exercise that right if that person is not within their custody?
And a follow-up to this question, just to guide you. This court cannot give orders in vain. You have to just know that indeed Mumbaya was in police custody or his disappearance was effected in police custody. Thank you for your question, Your Honor. Thank you for your guidance in this regard. Your Honor, paragraph 17 of the fact sheet expressly states that Mumbaya went to Congo police station to record a statement as regards the death threats he was receiving. Paragraph 18 of the fact sheet goes ahead to state that 8 hours later, Mumbaya did not return and his wife went to inquire on the same. Paragraph 19 of the fact sheet states that 2 witnesses came forward and stated that Mumbaya had been held at Congo police station.
In just maybe 1 minute, he was now perceived to have disappeared. And how admissible the evidence that may have appeared in between that possession is admissible, or how you can convince us that indeed Mumbea is probably being detained by the state.
Thank you for your question, Your Honor. Nadia provides that explanatory facts or facts that introduce an explanation to the facts in issue are relevant and indeed admissible. Your Honor, I alluded to paragraph 21 of the fact sheet, which put the Republic of Nadia at the UN watch list on matters of enforced disappearance. I proceeded to allude to the statement by the two witnesses pursuant to paragraph 19 of the fact sheet, who expressly stated that Mumbea had been held at Hongo police station. I then proceeded to equally allude to paragraph 17, where Mumbea had been receiving death threats and warnings telling him not to go and record a statement. Your Honor, all these factors point to one thing. Indeed, he had gone to Hongo police station, and his disappearance had been effected by the state. Your Honor, it is a submission that the absence of those records satisfies the element of concealment in regards to matters of enforced disappearance, which is why it is a submission that his disappearance was effected by the state, and therefore the court is well within its rights to issue an order of habeas corpus. Your Honor, I notice time is fast spent. I would like to wrap up on the second issue so I can cede the ground to my co-counsel. Your Honor, as regards the second bit of the second issue on the obligation of the state to conclude investigations, Article 2.3 of the International Covenant on Civil and Political Rights applicable to Nadia pursuant to Article 2.6 of the Constitution of Nadia provides that the state has an obligation to ensure persons whose rights have been violated have a right to effective remedy. Your Honor, paragraph 86 of the case of Florence Amunga Omukanda versus the Attorney General and two others, a 2016 decision by the High Court, hence persuasive, it was stated that the state has an obligation to investigate violations to human rights. Now, the obligation to investigate was further considered in the case of CK and 10 others suing through Ripples International versus the Director of Public Prosecution and two others, a 2013 decision by the High Court, hence persuasive, where the court stated that investigations should be able to establish the facts, identify the perpetrator, and lead to the punishment of those perpetrators. It is a submission that pursuant to paragraph 19 of the fact sheet, the state is yet to procure a conviction on the same. Equally, pursuant to paragraph 6 of the fact sheet, the police promised to get to the bottom of the matter as regarding the death of Tanjari's brother, yet nothing has been done in regards to the same. It is therefore our prayer as the petitioners that the court finds that indeed the Republic of Nadia, or rather the respondent state in this regard, failed in its obligation to conclude investigations, and that the disappearance of Mumbea and Whelan were equally brought about by the state, and that the state can issue an order of habeas corpus in regards to the same. And with that, I'd like to cede ground to my co-counsel.
The case, has the state completed investigations and made a total of the finding, or what is your view on the timeline that should be taken in terms of investigations? And do you have any legal support supporting the timeline or violation of the state on the timelines, or whatever it's supposed to do towards ensuring that the issues are investigated?
Thank you for your question, Your Honor. As I previously cited the case of Canada, where it recognized that a court in Canada held that 7 months was far too long to conclude investigations as regards violation of human rights. And it is therefore a submission that this being a state that has been described as an economic powerhouse, it indeed felt in its obligation to conclude the investigations.
What is the text that was applied?
The court brought about the fact that it depends on the peculiar circumstances of this case, which is why, Your Honor, I've alluded to paragraph 1 of the fact sheet that describes the
circumstances of the country or the circumstances of the case.
Of the case in which.
And does the economic statistics of the country have to do with the case? What is the relation?
Indeed, they have to. Thank you for your question. They have to. Your Honor, it is the obligation of the state to investigate this particular violation. It simply means it has the resources to do so, having this been described as an economic powerhouse. And in regards to time, I'd like to sit down to my co-counsel. Unless the bench director will. Okay.
Greetings, Your Honor. As previously introduced, I'm Kithenji Doreen Kizi. I'll be addressing this Honorable Court on the first issue on whether the state actors were in violation of the Constitution on quelling protesters. In the second issue, I'll be addressing the issue of excessive use of force, that it was in violation of the Constitution and the international human rights law, Your Honor. On the first issue, the state actors' actions on quelling protesters was in violation of the Constitution, Your Honor. I seek to recognize the right to demonstrate under Article 37 of the Constitution, which provides that the people of Nadia have a right to demonstrate. We do not dispute the fact that it is limited. This particular right is subject to limitations and therefore not absolute, pursuant to Article 25 of the Constitution, which actually excludes it from the rights that are absolute, Your Honor. Equally, I'd like to... Thank you so much, Your Honor. It actually, Article 24 of the Constitution lays down the factors to be put into consideration while limiting this particular right, Your Honor. The first factor is to consider the nature of this particular right. The second factor is actually to consider the importance of the purpose of limiting this right. The third factor is to consider the extent of limiting this right. The fourth factor, rather, Your Honor, is to consider the rights of other people and make sure that they are not prejudiced by the people who are exercising their rights. And the last factor, Your Honor, is to consider less restrictive means while limiting this particular right, Your Honor. And further, I will be demonstrating to this Honorable Court that indeed these limitation factors were not met by the state while limiting this particular right, Your Honor. As I was saying earlier, Your Honor, the importance of the right to demonstrate was actually stated in the case of Ferdinand Waititu versus Attorney General, petition number 169, 2016, which is persuasive in this court since it was decided in the High Court, where Judge Ongoto said that the importance of the right to democracy is to give a power to the powerless, Your Honor. This means that this particular right is actually very important for the people to express their petitions, rather, Your Honor, in public, Your Honor. I seek the court, since my time is over, to add me 4 minutes to conclude on. No, Your Honor, maybe 30 seconds for the rebuttal.
Then you will have 3 minutes and 30 seconds.
Thank you so much, Your Honor, for that. As I was of the Constitution, which actually stipulates that while implementing the rights of the citizens of Nadia, the state has to observe, it has to protect, it has to actually fulfill and to promote this particular right, Your Honor. And this was equally seen in the Serra case, Serra versus Nigeria, a 2001 case, Your Honor, where the judge in that particular case stated that while actually dealing with the rights, or rather implementing the rights of the citizens, the state has an obligation to respect the rights of the people. Respecting in this particular case, Your Honor, meaning they should not interfere with the rights. Your Honor, paragraph 9 of the compromise, it actually shows us how the state actors anticipated and waited for these protesters to come, and they actually lobbed tear gas before they could even engage. Your Honor, yes.
The demonstrations were not peaceful because the demonstrators were armed with stone sticks and some carried machetes. Then I'll take you to the next sentence, which goes, it was also argued by the states that some of the demonstrators were using this as a disguise to engage in breaking and entering. Then I'll take you next to the sentence on page, the next page, that goes, the Inspector General of the Police issued a warning to those taking part in demonstrations, stating that all who engage in criminal activities would be met with the full force of the law. So before you even take us to paragraph 9, how do you respond?
Thank you. Cited earlier, Ferdinand Waititu Ndongo versus Attorney General, petition number 169 of 2016, decided in this High Court of Nigeria, therefore persuasive, Your Honor. Paragraph 37 of the ruling of Justice, Judge Onguto, Your Honor, it actually stated that it was not uncommon for protesters to turn unruly and to actually turn violent, but this does not deprive them of their right to demonstrate. Equally, Your Honor, in the case of...
Therefore, what should happen? Should they continue to enjoy
it is necessary for the state actors to limit these particular rights. They have to meet the standards, or rather, the factors under Article 24, as I said earlier, Your Honor, which I already submitted before this Honorable Court, that the state actors were selective in fulfilling these factors and they did not meet them in entirety, Your Honor. And particularly, the last factor, which actually requires them to use less restrictive means, Your Honor. Before this Honorable Court, that indeed the state actors were in excessive use of force. Excessive use of force, Your Honor, is actually defined as using force beyond reasonable measure.
Counsel, can you address the issue that your time is up?
Thank you so much. Apologies for that, Your Honor. I'd like 1 minute to wrap up. Taken step by step of the occurrences that led to the death of Tangerine. Your Honor, if you look at these occurrences, they were unlawful. They were not justified. The police in that particular case, Officer Kilina, actually used force to deal with this particular demonstrator, Your Honor. And this is actually contrary to the 6th schedule of the National Police Service Act 11A of 20 armed. But the proportional, or rather, there was no proportionality with the force that was subjected to Tangerine, and actually what the officer, bearing in mind that Tangerine was not armed, and the force that Officer Kilina actually charged Tangerine with, Your Honor, this was unlawful, Your Honor, and it is therefore our humble submission and humble prayer before this Honorable Court that it finds that the state actors were actually in violation of the Constitution of Nigeria and international human rights law on quelling protesters and using force on civilians. Thank you. I rest my case and invite the respondents to respond if there are no further questions.
Thank you very much. We may hear the respondents, yes. Before you proceed, you know that you have 1 minute that was added to them.
Thank you, Your Honor. I'm Counsel Clement Wangel, representing the respondent, that is the Republic of Nigeria. With me is my co-counsel, Naftali Seneti. I will be addressing this court on first the jurisdictional admissibility and standing of the parties, and further issue 1, that is the actions by the Nigerian police in quelling the protest. And my co-counsel will address you on issue 2 and 3, that is the use of force and the enforced disappearance of Milan and Mudaya. In addressing my issues, I shall use 8 minutes of this court's time, and my co-counsel shall use 13 minutes in addressing issues 2 and issues 3. May I please this court or without further clarification? May I proceed? Thank you, Your Honor. In addressing matters admissibility jurisdiction, we as the respondents do not contend the jurisdiction of this court. We do submit that indeed this court has sufficient jurisdiction to listen to this matter, that the elements of matter presented by the applicants are admissible before this court, and the applicants have sufficient standing before this court. Further, we would like to talk about our own standing before this court. Pursuant to Section 3 of the government.
And that the entire length is only 1 judge seat?
No, they cannot be entire. It's 1 judge seat because what the judge decides is what will be applied. In addressing the substantive issues, that is issue 1, the use of force by the Nigerian police, I have divided my argument into 3. That 1, I will prefer to start from my third argument, that is the limitation of the right to demonstrate, as that is the final issue that the applicant has just presented, and it will be much better to begin with it. But I will also submit that the police were fulfilling their mandate as state actors, and further that the protesters' conduct failed to meet the legal threshold of enjoyment of that right. So I will start with the limitation of the right. This states international conventions and treaties are applicable in this state by dint of Article 2, 5 and 4 of the Constitution of Nadia. Therefore, this is admissible before this court. I will start with Article 24 of the Constitution of Nadia. The first test it gives is the nature of the rights. Article 51 of this Constitution stipulates rights that cannot be limited. However, the right to demonstrate, picket, and assemble is not one of those rights. Therefore, it is a right that can be limited. The second test it gives is that the purpose of the limitation. What is the purpose of the limitation? As we can see in paragraph 5 and further paragraph 9 of the fact sheet, these protesters were carrying machetes, they were carrying stones to an extent where they were using those stones, throwing them at the police officers, throwing them at fellow passers-by on the street. Therefore, the purpose of our limiting of this right was to preserve national security. Section 24 of the Police Act stipulates the functions of the police officers, which include maintenance of law and order, preservation of peace, and this is pursuant to Article 238 of the Constitution of Nadia that gives the principles of national security order. Our submission is that we, as the police, as the respondent representing the police, did adhere to this. The purpose of our limiting of that right was justifiable. We were looking at the rights of fellow citizens, we were looking at the rights of us as the police.
First, the actions by the state were legal. How are they legal? By basis of action, or Section 61 of the National Police Service Act, and further in Section 88 of the Penal Code. In Section 61 of the National Police Service Act, it states very clearly that a police officer can use force when circumstances necessitate. Your Honors, in the facts pattern in paragraph 5, we see a mob of people. It is important to note that
persons with the force used against somebody.
Your Honor, during the
control their temperament, that out of frustration, triggered by any frustration, they just shoot to kill.
Your Honor, that fact is not clear in the fact pattern, and I agree.
But Officer Kilida Kilao is a police officer in the state of Nadia, and out of frustration decided to shoot to kill.
Your Honor, we submit that that's the necessity of Section 88 of the National Police Service Act. It states that there shall be disciplinary actions against any officer who acts extrajudicially. Your Honor, this was a foresight of officers like Kenyan, and we shall not grant the prosecuting officer in the work of the independent statutory.
Even just looking at the accountability of the government, looking at the company, there are very many other casualties that came from the protests, but only Officer Kilina has been pursued because of the information that was released to the public. What is happening to the police involved in other casualties?
is not peaceful, then they'll not enjoy the protection. And in peaceful, Your Honor, it is regarded from the statement of facts that all those demonstrations conducted by...
Counsel, one last clarification.
Yes.
To understand your train of thought. He's equally making attempts to enjoy his right to demonstrate alone, but is armed. Should my right be extinguished or limited for purposes because he is armed and I am not?
No, Your Honor. The case of Ferdinand Waititu Ndung'u versus the Attorney General and others clearly stated that you cannot stop a procession because one person is armed. Your Honor, from the facts...
But what did the police do?
the police dispersed protesters for the following reasons I'm going to give before this.
Yes or no?
No, Your Honor.
Do you accept any form of responsibility for the shooting?
Your Honor, it is clear that...
Counsel, do you accept any form of responsibility for the shooting?
No, Your Honor.
And the fact that you are relying on is a fact in issue that is contested.
Responsible for Mumbaya's disappearance, and therefore there is no violation of the Constitution and any other international human rights law. And subsequently, my lords and my lady, the order for habeas corpus cannot issue under the given circumstances. My lords and my lady, the elements of enforced disappearance have been clearly laid. Where was not seen at Hongo Police Station.
Just a follow-up, Counsel, following your train of thought. The wife alluded to the fact that she left home when
Good afternoon. Thank you so much for joining us for this session. I would like to give my co-judges an opportunity to introduce themselves, and then we're going to give our comments. Okay, they are going to introduce themselves as they make their presentation, but I could state their names. From the far right, Caroline Kaunda. We have Catherine Kahiu, and we have Vivian Atiam, and I'm Patrick Zomo. All of us had an opportunity to sit in during your presentations, the research presentations, and some of us also had an opportunity to mark and look at your research papers. And I'll be tackling the presentation part. Basically what you did yesterday at the lecture hall, and my colleagues are going to handle the paper itself. So, the presentation, generally, we want to commend you guys. First, Fiki and your team, the organizers, we have to commend you, you did a good job. The bailiff, Abigail, thank you so much. And the participants, of course, for bearing with us. I think we were almost the last people to complete, but you bear with us until we finished the last person. Only one team did present, Team 206. Any member of Team 206 here? Not here. But the other members that did the orals, we want to start by saying that you guys were good, generally, for the presentations. Yeah, and we mark the presentations out of 30. You'll be getting your score sheets later. And it was an average of 3 judges, myself, Vivian, and Mr. Andrew, who is absent today. And some of the things that we noted are analyzation of the question. You see, a research paper, basically we're not expecting you to speak about the same thing, all of you. And just like the presentations in the moot court you've noted, we're experiencing people just saying the same things. Yeah. The beauty of research is that you can decide to look at a question, analyze it differently, and bring another angle to look in at the same thing. Yeah, just like Professor Githumike was saying, there's no correct or right answer in the legal profession. It's all about how you bring in an angle that maybe the drafters of the question didn't anticipate, or they didn't see coming. Yeah. So I think for some of us, they really had a narrow interpretation of the question, and that could be told from the presentation itself. Because the moment we ask you a question about the Kenyan legal framework, ideally, and you're speaking about national security and human rights, and you can't respond to that question, then there's a problem. In as much as you didn't capture it in your presentation, we expect that at least you captured it in your research, right? So next time you get a question, try and look at it in a wide view, so that your presentation is not narrowed down to some aspects. And then time management. This didn't affect some of you, but I'm going to single out just 2 cases that we had. One case, the bailiff was there trying to show you time. You saw the stop sign, and you give a blind eye. It's proper practice that when your time is up, just say that you need some additional time to complete. Yeah, because if it was you on this side of the bed, you'd want that, because I don't know, it's just wrong, right? It's wrong to have the stop sign shown to you and the judges, and then you don't want to stop. Again, it's also good to use the time that you've been given. It doesn't make logical sense to complete your presentation after 5 minutes. Yeah, you have all 15 minutes to make your presentation, then after 5 minutes you're already done with your presentation. So they tell you the time in advance, so you structure your argument. You know that you're going to be able to dispense with your argument in the required 15 minutes. You know what to say, what not to say, what to emphasize, what not to emphasize, yeah, within the 15 minutes. Mastery of content was the next thing. Remember, we are judging the presentation from a point of knowledge that this is actually your paper, right? So the moment a question that is directly related to what you've been saying in the presentation is posed, and you can't respond to it adequately, then we don't have any other way of proving that you're actually the one who authored the paper, right? So it starts to cast some doubts on whether you actually are the one that wrote the paper. So master the content of what you're presenting. That was clearly visible for most of you, but then some of you, there was a slight challenge. I don't know whether you have been afraid or something, but then that didn't come out so clearly, especially during the questions. And that leads me to respond to questions. Yeah. For the research, unlike the moot court, we let you present first, and we ask the questions later. Yeah. So the questions, like I can recall, let's say like 5 of you didn't capture clearly the whole aspect of development while making your presentation. So the questions were coming in to help you clarify on things that we thought didn't come out clearly in the presentation, especially the issue of development, the issue of recommendations, when we thought that there was a deficiency in the recommendations that you gave, or we needed you to elaborate something. Some of you didn't take that so well. They thought it's like, there are a few of you just finished their presentations and you wanted to go and sit. It's like it's a burden to respond to questions. So next time, just keep an open mind, respond to the questions to the best of your ability, and make every judge feel appreciated. You see, the good thing is we are a bench. You will impress one judge and offend one judge. Because let's say we've asked 3 questions at a go, and then you respond only to one judge's question. What happens to the other judges? Remember, we're human beings, just like you. Yeah? If it was you, you pose a question, then somebody tries to evade it, they don't respond to it at all. What happens? Yeah? And there's going to be an average score. So as a presenter, you need to capture the attention of all the judges, respond to all the questions, and yeah. And then, comparative studies. We also had a problem with these. Yeah? Some of you are just stating a country. For example, you say Ghana, for instance, or Ethiopia, Egypt, but then you don't go to substantiate. You see, if you're comparing it to Kenya, we need to see like you're comparing the legal framework, and you've told us nothing about the legal framework in Ghana. So how can you actually compare without us seeing that, without us also being able to look at the issues, the legal framework, and interrogate if actually that was a good choice of a comparator country. Yeah. So the next time you want to do a comparative study, just go into a little bit of detail so that we can be able to read and understand where you're coming from. Because the whole essence of a comparative study is to learn lessons. Yeah. You can't learn lessons when you've not told us they are doing better in this and this is where we're lagging behind. Right? We need to be able to see where they're actually doing better at. Right? And then we had, as I conclude, audibility and confidence. This wasn't so much because again you're very near to the bench, and I don't think this creates a lot of problem. Only the eye contact with some of us, they're just looking all over the place. I mean, the bench was only 3 people. What you needed to do is just move your eyes as you make a point and not look at the ceiling, the lighting, and people coming in and out. Yeah. So, but these we didn't have a lot of problems with. And lastly, one thing I'm going to say to us, the whole essence of trial advocacy and what we do in a moot court and a presentation generally is to persuade other people to actually agree with how we view things. Yeah? And the whole essence is to persuade a fact finder who is a human being. And one rule is that you need to make yourself likable to that person. That's the starting point. Yeah? Because the moment we like you as a bench, guess what happens? We like what you say, even if you say nothing. It's serious. There's this book by Keith Evans on the dimensions, rules, and psychology of trial advocacy. He said, just try and be liked by the fact finder. Just try and be more likable than your opponent. Yeah? Even when you have nothing, the judge is always going to try and be soft on you because they already like you. Yeah? But the moment you have this attitude, you want to speak to us like, this is the moment you're on this side and you're on that side, it already connotes that you are on that side, yes? You know what it means? Yeah, so it's not always you on that side. At times you are also on that side, and we appreciate the people who are on this side. Yeah? And that's it. And roadmap. I thought a roadmap was really important. I gave it in most of my comments. Since the moment you just introduce yourself and you start speaking, you get lost. Yeah? Because if you do not have the written research paper, it's very hard for us to follow your presentation. Yeah, so it's always good. Like for instance, I did have an opportunity to get the written research because we only had 2 copies and my seniors were using them. Yeah, so the moment you lose me in your introduction, I'm totally lost. And okay, I tried as much as possible to follow most of your part of the paper and look at it, but then at times I was just completely lost. So to start off, just give us a roadmap. This is what I'm going to say. I've divided my paper in these parts. So I guess that's it, and I started by saying you guys did well compared to what my colleagues are going to say. I'm just very new psychologically, but the presentations were really good. I don't remember giving anyone less than what you're going to see in this question. Okay, thank you so much, and enjoy the rest of the session.
I'm a legal officer at the National Council for Law Reporting Kenya Law. One of our judges who's not here with us today, Mr. Andrew Halomere, is my senior at Kenya Law as well. And I'm going to give comments for both of us. And it's basically from our legal practice. We are a law reporting and law revision institution. Since you all study the Kenyan system, you understand the importance of law reporting. And you also interact with the statutes, so you understand why legislation is important. I know most of you in your third year of legal studies and fourth year have already done legislative drafting. There are 2 aspects of legislation in our legal system. We have legislative drafting and we have law revision. Now, legislative drafting, the drafting of the bills, preparation of the statutes into law. Law revision starts after the act is enacted into law, and we track legislative developments from there. So I'm going to touch on citation of legislation in your research papers, citation of case law in your research papers, the ideal reference materials for our kind of jurisdiction, which is a common law jurisdiction, your understanding of the legislative process in Kenya, and finally your understanding of amendment acts. I'll start with citation of legislation, and it was our general understanding that some of you were comfortable with citation of legislation, but the majority had a problem citing the Kenyan laws in full. For instance, for the Constitution, you will not cite it as just the Constitution. In Kenya, it is cited as the Constitution of Kenya 2010. That is the first citation. Then when you proceed from there, it becomes the Constitution. If you'd like to proceed as the Constitution of Kenya 2010, that is all right. But kindly don't shorten it and abbreviate to COK. You cannot cite the Constitution as COK in a research papers. It is very important for an advocate to understand how to cite legislation, because that is the first instance where a judicial officer will see that you actually know your law. And ignorance of the law is not a defense. And it is a very serious issue for an advocate not to know how to cite legislation. You can easily lose a case just because you cited the legislation wrongly. So we are not here to reprimand you. As your senior, I'm here to just correct you and just give you insight into citing legislation, something that will be very important in your career beyond the law school. And secondly, citing national legislation. I noticed that you were citing as an act and the year that it was passed. We have acts that have act numbers and acts that have chapter numbers. The law in Kenya requires that all statutes should have a chapter number. What do I refer to as a chapter number? I'll give you an example. a statute that you're all familiar with, the Evidence Act. Evidence Act is Chapter 80, Laws of Kenya. So anytime you cite it, it is Evidence Act, Chapter 80, Laws of Kenya. There are statutes that were passed since 1995 that are yet to receive chapter numbers. That doesn't mean that you now cite it as, let's say, Kenyatta University School of Law Act. Such an act was passed in the year 2018, and it is the first act in that year which receives an act number. So it will be Kenyatta University School of Law Act number 1 of 2018. So at all times you have to cite an act if it has an act number with the act number. If it has a chapter number, you use the chapter number. That is your first citation. If you want to proceed, you may proceed with that, Evidence Act Chapter 80 Laws of Kenya, or simply Evidence Act, as long as you have it in your footnotes. Okay? Thirdly, citation of international instruments. I noticed that most of you are not familiar with the citation of treaties. There is the first article or preamble in a treaty that will guide you on how to cite that instrument. And anytime you come to read these instruments, make sure you look at the preamble and section 1 on how to cite it. If it doesn't have, there's normally a metadata section. If you collected it from, let's say, the United Nations Treaties Collection Repository, they will provide you with a metadata. How to cite it, the year it was ratified, when it was adopted, whether it needs domesticated legislation, all that information is there. Kindly make a point of interacting with that information. It is very important for an advocate to know the title of an instrument, know when it was ratified, how it is going to be enforced, how it is supposed to be interpreted. On your interaction with amendment acts, in all your research papers, I noticed that you refer to the Security Laws Amendment Act. What stood out for me was your citation of the Amendment Act. You have to understand that when we have national legislation, future developments of legislation are introduced in form of an amendment act. It proposes amendments to existing law. So it is not an independent statute, but it is coming in to amend existing laws. So if you cite it in your research paper, it will be Security Laws Amendment Act number 19 of 2014, not Security Laws Act. It is an amendment act, so you always have to cite that it is an amendment act. And then in your research work, you will not state that the Security Laws Amendment Act introduced something, proposals to law independently. Because it is amending existing laws, you always have to cite that it has amended existing law. And if you could proceed to cite the specific law that has been amended, that gives clarity to the judge who is marking your paper, or in terms of a case in court, the person you are addressing, that you understand the amendment and the proposed amendments that have come in and how to interpret them and enforce them. It is very important for a lawyer to understand citation. That guides your interpretation of the law and it guides your implementation of the law. Okay? Then citation of case law. For the Kenyan system, we have print law reports. I'm sure you've all seen the Kenya law reports. And we have the online edition of the law reports. I'm sure you've all interacted with the Kenya law website. When you're citing the online cases, you have to cite, there's a special citation, the EKLR. Always cite it that way. If you're citing from a print law report, you always have to cite as KLR. If it has a volume number, insert the volume number. If it has a year of publication, which it always has, make sure you cite the year of publication. And in the introduction pages of the print law report, there is a guide on how you're supposed to cite the law report. Ensure that when you're reading a law report, you also look at the introduction pages to learn how to do the citation. Style. print law report, like the Kenyan system, there is a guide on how you're supposed to cite it. Kindly observe the guidelines. Reference material. Using the law, you need to know how the law is made, how does it become law, okay? So there are institutions which are involved in this kind of work. Apart from the Parliament, there is the Kenya Law Reform Commission, the Office of the Attorney General, the National Council for Law Reporting, the Office of the Government Printer. You might not have everyday interaction with these institutions, but when we come to be presiding judges for your moots, we can interact on this level. We will leave our contacts with you for further discussion. You can visit our offices. Just engage us. We can assist you on this, learning process. How do we cite our law? How do we access information on gazettement of laws? How do I learn how to draft a law? Don't feel shy that because you're a student and we are advocates that we are not supposed to interact with you. We are all colleagues in this profession. Once upon a time we were students and now we are advocates. So once we walk past that door of opportunity when we are admitted to the bar, we don't forget you, our small brothers and sisters. We know the challenges, we know how it can be difficult to access information, and we are ready to assist you. You're welcome to interact with us, okay? I wish you the best in your studies, and you did well in your presentations. We were impressed. Okay, thank you.
Good afternoon, everyone. My name is Catherine Cathy. Most of you know me. We've interacted in the last editions of Teaching Secrets. So if I'm familiar, don't worry. So, my colleague has actually said a lot of things that I wanted to say. I won't repeat what she has said, but what really stood out for me is the fact that guys don't know about IRAC. Anyone? IRAC? Issue, rule, application, conclusion. Very important. If you don't arrange your research paper in that arrangement, how will I even understand where you're going? Then you don't apply at all. You will even be confused during your oral presentation because your work doesn't have a procedure that is presenting. You're just confused. You're all over. It's very important. Another thing is grammatical errors. What is fragrant and flagrant? What's the difference? One is a smell and another one is what? Why do you have such kinds of little errors that will take away marks from? And remember, research paper is 70 marks. Oral is just 30. So if you can get 70 out of 70 in a research paper, do you need oral? Just ask them. As a formality, no. You just need to just present whatever you have. And IRAC is always held. This question was on debate. You're supposed to give both for and against. You're supposed to debate. You're supposed to see what's your debate in this, what's your stand in the conclusion. You didn't give for, you didn't give against, you just stated examples of terrorism. All of you actually, most of you, not all of you, most of you just give examples of terrorism. Then you're wondering, is terrorism the only national security threat? Or is it the only issue that shows the ability to reconcile human rights and national security? IRAC. If you don't identify the issue, if you don't state the law, if you don't apply it, if you don't give us a stand, then you just get very low, and that's very important. Okay. So I think that's the only thing that I had. Unless there's any questions, but we don't have time for questions. My colleague will conclude.
Good afternoon. My name is Caroline Kaunda. I'd like to invite Timothy Kalu one of the organizers, to announce the teams that are proceeding to the finals. But in concluding what we've been saying, and also touching on memorials, especially memorials, I'll be very keen to tell you that in as much as you know the law, if you state for me just the law, it doesn't help you, because in coming up with memorials for the moot, we have now the FIRA, in that you're starting with the facts, identify the issue, then now do your research, then application of the law, link this fact to the law that you have identified, and then editing of your work. Have someone read your work so that you don't have grammatical errors. And also, when we are interacting with the memorial or your research paper, it's the only chance you have of waiting. When you're speaking orally, you can defend yourself, but your work has to defend you. So follow the rules, okay? So,
thank you very much. I apologize, I must apologize for having you out of this session. But we are quite late to describe our final direction with the second rope and waiting for the participants to complete. So I'll just keep as fast as possible. I invite Mike Bruno, who is of course the chair in the talent center. We have the honor of announcing who will be going to the final.
Good afternoon. Once again, my name is Mike Atino. I am in charge of the Talent Center, and we have the results here for us for the teams that will proceed for the final level. These results, as you can see, we have increased the number here. We increased the number of observers to 2. We have observer number 1, Julie, and observer number 2, Kichwell, and the executive officer is IDC. Mr. Matthew Mwida, and I, the chairperson, Mr. Mike Atieno. This result has been signed by all of us, and it has also been signed by the president of the Kenyan Moot competition. And together with other observers, we concur, confirm, and agree that these results are real, and nothing has been done to them, altered anything. We have brought them to you as they are. Now, the teams that will proceed to the finals are team number 204, and another team that will proceed to the finals are team 308. We meet at the old moot court right now. The judges are seated. They are waiting for you. Thank you.
We'll do the tossing of the coins in the moot court. So the team 204 and team 308, kindly let's move the kids and leave the old moot court.
striking the balance between the respect of human rights and maintaining national security. I invite the bench to continue.
Good afternoon. The court is in session. On behalf of the bench, we would like to welcome counsels for the applicants, petitioners, and counsels for the respondents. I would like I will invite my colleagues to introduce themselves from my extreme left to right.
Emmanuel Bita.
Irene Icom. Rosemary Mukoka.
James Kironji.
And I, Muhammad Mugambi, presiding. For the first counsel for the petitioner, please address the court.
Good morning, good afternoon, Your Excellencies. My name is Kadima Cedric. I'm the lead counsel for the petitioner, the matter being the Nadia National Human Rights Commission, in this regard, the Commission versus the State of Nadia. With me is my co-counsel, Ms. Nakula Masinde. Together we are going to demonstrate to demonstrate before this court on issue number 1 of the merits, number 2, and number 3, that it should be admitted and thus the orders that you will seek be granted. Your Honor, personally, I shall take 16 minutes of the court's time to demonstrate that issue number 1 of for determination has merit. My co-counsel, Ms. Nakula Masinde, will take 14 minutes, Your Honor, will take 13 minutes of the court's time to demonstrate that issue number 2 and 3 has merit and thus be admissible and the prayers be granted. Your Honor, with the permission of the court, we shall spare 1 minute for rebuttals. I beg to proceed. Your Honor, should I address this court on the preliminary issues or it should be read from our substantive submissions?
Counsel, please proceed with your substantive issues.
Thank you, Your Honor. Your Honor, I have stated before and on several times that milk and honey are of different colors, though they exist in the same house peacefully. The matter arising out of issue number 1 is a matter of national security vis-a-vis human rights. And Your Honor, the petitioner submits this afternoon before this court that the actions by Nadian state actors to quell the demonstrations was in violation of the Nadian Constitution and international human rights instruments which they have ratified. Your Honor, the main right is the Article 37 right of the Constitution of Nadia, the right to assemble, the right to picket, to public authorities and to present petitions, Your Honor. And Your Honor, as was stated by the High Court in 2016 in the case of Ferdinand Waititu Ndung'u versus the Attorney General and 12 others, it noted that the right under Article 37 is a precious right. The right provides an alternative form for persons to participate in democracy. And Your Honor, from the statement of facts, 4PC and Kituo are advocating for electoral reforms. They are protesting against extrajudicial killings of the police, and therefore they deserve the protection of that right. We as the petitioners do recognize that Article 37 has a caveat that demonstrations must be peaceful and that the demonstrators must be unarmed for them to enjoy that right, as was the position of the Court of Appeal in the case of Hussein Khalid and 16 others versus the Attorney General and 2 others. However, this court should also take note that the same Court of Appeal in the case of Hussein noted that demonstrations in some way always results to violence. And in regard to that, the police must exercise some restraint. The police must exercise some caution when dealing with demonstrators. And therefore, they should show tolerance, not disperse the demonstrations because 1 or 2 or some of the demonstrators are armed or some of them show violent conduct. Therefore, what is the obligation of the police when these demonstrations in some way turn violent or some demonstrators are armed? The obligation of the police, as was stated by the High Court in the case of Ferdinand Waititu Ndung'u, which I've stated before, and the decision was affirmed by the Court of Appeal, the police are required to isolate, they are required to arrest all those persons demonstrating unlawful conduct during demonstrations. But have the police in Nadia done that? No, Your Honor. They have instead dispersed the demonstrators. Your Honor, we know the respondents will rely that due to the past history that the demonstrations always resulted to violence. But the question before this court, where were the police when the demonstrations were resulting to violence? Your Honor, the Court of Appeal affirmed the same decision in Ferdinand Waititu that the police are supposed to ensure that demonstrations are peaceful by protecting the demonstrators themselves, by protecting the public themselves, Your Honor. But in this regard, the police in Nadia have failed those obligations, Your Honor. And Article 37 right has a twofold obligation to the state. The state has a negative obligation not to interfere with the enjoyment of Article 37 right, and it has a positive obligation to ensure fulfillment of Article 37 right. To support my argument, it was the same decision by the Human Rights Committee in General Number 34 on Article 19 of the ICCPR, which stated these two obligations respecting the right to assemble, demonstrate, and picket. Therefore, did the actions of Nadian state actors to quell the demonstrations in compliance with the negative and positive obligation respecting to Article 37 right, of which as the petitioner, I submit that they did not for the following reasons, Your Honors. First, in regards to the negative obligation, if there is suppression of demonstrations by the actions of the state, for example, through issuing of orders warning demonstrators with no justifiable reasons that they should not attend demonstrations and labeling them as criminals, labeling them as power-hungry individuals, Your Honor, that is a suppression of demonstrations. This was the same position of the African Commission in the case of Bumne and others versus Cameroon. Number two, if the use of force against peaceful demonstrators, then it will be considered a violation of the state's negative obligation. This was the same position in the Supreme Court, in the Court of Appeal, in the case of Hussein Khalid, which I've mentioned before. Your Honor, the police in Nadia, Officer Kilina and his crew, went to a place whereby they suspected that it will be the epicenter of the demonstrations. Instead of monitoring the demonstrations, they waited to disperse the demonstrators. And what did they use, Your Honor? They first threw tear gas at them. They did not stop there. They used water cannons at peaceful demonstrators. As if that was not enough, they took their hand batons and used them against demonstrators, Your Honor. Your Honor, even that did not satisfy them. Actions of Officer Kilina, he cornered Tanjari. Tanjari was an armed protester, protesting against excessive use of force by the police. She was running for her life, but Officer Kilina cornered her, beat her with a hand baton, kicked her with heavy police boots. And you know the nature and way police boots are made, Your Honor. Yes, Your Honor.
A clarification from the bench. What then do you propose should be the ways in which police can use to disperse armed protesters or rioters? What other methods other than tear gas, water cannons, and hitting them with police batons? What other methods can you propose the police can use?
Your Honor, I'll respond to your questions in two ways.
Add on to that question, what is the place of the Public Order Act that supports the way in which protests are to be conducted? And what is the place of the attire of the police? What does that demonstrate when they wear the protective gear to the protesters?
Thank you, Your Honor. To answer the presiding judge's question, I'll answer it in two ways. First, before I proceed to the second judge. In the first question, Your Honor, the police first are required to disperse protesters if they turn violent by using non-violent means first. This is by using tear gas, of which as the petitioners, we do not contest that, since it is a non-violent means. But if the demonstrations turn violent? Does it justify for the police to use live bullets against demonstrators? Your Honor, in the case, Your Honor, the police are supposed to use rubber bullets during demonstrations.
Counsel, how many victims do we have who were shot by the police?
Your Honor, from the facts, first, it is uncertain as to the many number of the demonstrators who were shot, since we are told that some of the demonstrators were shot with live bullets. And secondly,
so
we are informed...
we do not know how many.
Your Honor, for sure, there are many, as the petitioners you can submit. The police know that, Your Honor. Your Honor, I beg to proceed to answering your question. The Place of Public Order Act, in the case of Ferdinand Ndung'u, the same case in the High Court, they went further to state that the Public Order Act does not seek to limit the Article 37 right. Rather, it seeks to regulate public processions and ensure public order. And in that regard, it has several provisions as to how a demonstration can be declared illegal as per Section 5, Section 510 of the Public Order Act. And Your Honor, the respondents did not give any justification as to whether the demonstrations were illegal. Instead, they went ahead to disperse the protesters with no justification, Your Honor.
Counsel, let me ask you a question.
Yes, Your Honor.
Is Article 37 an absolute right?
No, Your Honor.
It is not absolute.
Yes, Your Honor.
Can it be limited as provided for in Article 24?
Yes, Your Honor, it can be limited.
What is the duty of the police in terms of guaranteeing the right to protection of property under Article 4?
The duty of the police in ensuring that there is no destruction of property under Article 40, they are supposed to arrest, they are supposed to isolate.
Can the police act preemptively in terms of safeguarding other people's right to property?
No, Your Honor, until it happens.
Until it happens?
Yes, Your Honor.
There must be destruction before the police intervenes.
During the breaking into private property, the police can intervene.
Before or after?
In either way, they can intervene before, during, or after.
Now let's look at those rights. Are rights enforced horizontally or vertically or both ways?
Rights are enforced both horizontally and vertically, Your Honor.
So a citizen has a right to protect the right of another citizen?
No, Your Honor. A citizen has no right to protect. The obligation to protect the right of a citizen solely belongs to a state.
You're sure?
Yes, Your Honor.
There is no case law in this country that talks about application of rights.
Your Honor, to support my argument, the case of Zimbabwe Human Rights NGO Forum versus Zimbabwe, the African Commission.
Speaking of local jurisprudence.
Your Honor, on local jurisprudence, the same case of Kenya National Human Rights Commission versus the Attorney General and two others, it was the same position.
Okay. Point me to a specific article of the Constitution that says rights are only enforceable horizontally.
Your Honor, there is no specific provision in the Constitution whereby it is stated that rights can be enforced.
So there is no course of law that submission is dependent on?
No, Your Honor. This is dependent on constitutional principles. Your Honor, if I may proceed with my submissions. Your Honor, therefore I submit that the state violated its negative and positive obligation respecting the right to assemble, demonstrate, and picket. And thus, Your Honor, if you were not granted these orders, that the actions of state actors to quell the demonstrations violated the right to assemble, demonstrate, and picket, Your Honor, it will lead to a state whereby citizens can no longer enjoy the right to assemble, demonstrate, and picket on the verge.
Counsel, on
Yes.
that point, how long have these demonstrations been running?
Your Honor, soon they have been running before the electioneering period.
Well, but they've been running for a number of weeks, these demonstrations.
Yes, Your Honor, they've been running for a number of weeks.
Counsel, you are also aware that the government spokesperson did put out a statement on how these demonstrations were getting violent.
Yes, Your Honor, I am aware of a report given by the spokesperson of the police, but it's not part of a witness statement before this court, so we cannot ascertain as to the truthfulness of such information.
Counsel, having said that that is not part of court records, you have alluded to the fact that many people were shot, isn't it?
Yes, sir.
By the police, the respondent state agents. Do you have any ballistic tests to ascertain that the gunshot wounds from the victims are actually from the guns from the police officers, or they are also not part of the court records?
Your Honor, I beg for them to be considered as part of the court record, since we are even when
where they? Can you please produce it to our building so that we can peruse it?
Your Honor, after court session. Your Honor, I was submitting before this court that if we are not granted the prayer that the state violated the right to assemble, demonstrate, and picket, what will be the position of children like Tanjari's brother who are playing in the field and the police went there to shoot like bullets? Your Honor.
If I may ask you a question, I think my sister had alluded to the warning had been issued by the government that the protests have been happening for some time. And I want you to address me on the 6th schedule of the National Police Service Act on the conditions on use of force, particularly subsection 1 that talks about police using nonviolent means, unless the nonviolent means will be ineffective or without any promise of achieving the intended results. What's the place of that within this situation?
Your Honor.
Counsel, respond to that question while you are winding up. You have 2 minutes to wind up.
Yes, ma'am. To answer your question, the position of the 6th schedule of the National Police Service Act, as you have said before this court, the police are supposed to first use non-violent means. If they fail, then they have to resort to violent means. But violent means does not mean the police to shoot live bullets at demonstrators. And as was considered in the case of Lucas Omoto and 2 others versus the Attorney General and another, Your Honor, whereby the police used live bullets to arrest a person, the Court of Appeal gave a criteria that if you are to use force, like use of live bullets, you have to consider if you are pursuing a dangerously armed person, but was tangially armed. It gave a second criteria that if you are on a hazardous operation, but the police were not in a hazardous operation, they were called just to monitor a demonstration, of which they didn't. And thirdly, if it's on public interest, then they will be required to use force. They have not demonstrated any of the above in their submissions. And therefore, Your Honor, I beg to call my co-counsel to proceed with the arguments of submission. I beg to take my seat.
Thank you, counsel, for your most eloquent presentation.
Thank you.
Good afternoon, my ladies and my lords. My name is Masinde Nafula, and I'm going to be presenting on our second part of Limb 2, and I'll conclude with Limb 3, and finally I'll put our prayers before this court. My lord, the failure of the state to conclude investigations was in violation of the Constitution and other international
Counsel, direction from the bench, can finish up with the duty to investigate, begin with enforced disappearance.
Thank you, my lord. My lord, enforced disappearance of Mumbea by the Nadia police is in violation of the Constitution and other international human rights law. Article 2 of the Convention Against Enforced Disappearance, as well as Article 7 of the Rome Statute, have clearly laid out the elements of enforced disappearance as follows. Firstly, there has to be deprivation of the right to liberty of the subject. Secondly, there must be involvement of state agents, whether indirectly or by acquiescence. And lastly, there must be refusal to disclose the whereabouts of the subject, my lord and my ladies. As extracted from the facts together with the definition and elements of enforced disappearance, firstly, there was the deprivation of Mumbea's liberty. When you're reading the facts from paragraph 18 through to paragraph 20, it is demonstrated that Mumbea indeed made a decision to go and report to Hongo police station, and in paragraph 20, 2 witnesses come forth to indeed confirm that Mumbea was held with them briefly at Hongo police station before he was moved, my ladies and my lords.
Secondly, there is the involvement of government officials, who in this case are the police at the Hongo police station. And lastly, the state has refused to disclose the fate of Mumbea and the whereabouts of Mumbea to the family. My lord and my ladies, the Human Rights Committee, in its communication 950/2000, stated that enforced disappearance in itself poses a threat to various human rights, namely the right to liberty as enshrined under Article 29 of the Constitution of Nadia and Article 9 of the ICCPR. Secondly, enforced disappearance poses a threat to the right to life as enshrined under Article 26 of the Constitution of Nadia and Article 6 of the ICCPR. And lastly, enforced disappearance poses a threat to the right not to be subjected to torture, cruel, inhuman, or degrading treatment, my lords and my ladies. The Human Rights Committee, in the case of San Juan Arevalo versus Colombia, held the state of Colombia liable for enforced disappearance and for violating the rights of life and the right to liberty and security of persons after the San Juan brothers disappeared after having been arrested by the Colombian police, my lords and my ladies. It is therefore our prayer that this court hold the state of Nadia responsible for the enforced disappearance of Mumbea, and failure to do so will provide a climate and will facilitate instances whereby the citizens of Nadia do disappear and no one is interested in...
Council, slow down.
Thank you for that, my lord. I apologize.
You're on the right track. Slow down.
Thank you, my lady. The state of Nadia does pray that this state, that this court hold the state of Nadia responsible for the enforced disappearance of Mumbea in order to prevent such instances in the future, my ladies and my lords.
You're leaving a key element, which I don't know how you're going to marry that with your submission, because isn't it that there was a call for him to come out of hiding?
Thank you for that question, my lady. The main reason why Mumbea went into hiding, my lady, is because immediately he released that video of Kilina shooting Tangerine, he began receiving death threats, my lady, from anonymous sources, my lady.
And then he was called out to come and give a statement as a witness.
Thank you, my lady. Indeed, Mumbea came forth to report a statement at Hongo police station, and my lady, it is from there on that we are unable to trace the whereabouts of Mumbea, my lady.
You are not communicating.
Yes,
that is okay, proceed on.
Thank you, my lady. Having submitted that, we the petitioners do seek that this court exercise its mandate under Article 23 of the Constitution of Nadia, together with Section 389 of the Criminal Procedure Code, to order the Inspector General of Police in Nadia to either produce Mumbea before this court to be charged or to be released if no charge is preferred against him.
Counsel, from a brief reading of the facts, wasn't the wife of Mumbea taken around the police station, shown that Mumbea is not being held there? What do you have to say about that?
Thank you for that question, my lord. It is the petitioner's submission that this was just stage management by the police in order to cover up the issue that we were holding Mumbea in custody at Hongo police station.
Counsel, what evidence do you have that Mumbea was present at that police station, yet there is no record in the current book indicating that he was booked in?
Thank you for that question, my lord. Two witnesses, my lord, in paragraph 20 have indeed come forth to confirm that Mumbea was held with them briefly at Hongo police station before he was moved.
Do you have sworn witness statements to that effect?
My lady, the petitioners currently do not have sworn statements.
You want to submit it after court?
No, my lord. The petitioners currently do not have sworn statements. However, we do pray that this court consider the credibility and reliability of the statements of those two witnesses and not to dismiss them merely because, my lord, we have failed to adduce the sworn statements of the witnesses, my lord. My lord, having established that, I will move back to issue number 2, which is that the state's failure to conclude investigation was in violation of the Constitution and other international human rights law. My lord.
Question. How can the state be held responsible when there are no witnesses? Can the state now create the evidence just to show that they are complying with the obligation? From the facts, what evidence have they failed to investigate?
Thank you for that question, my lord. The state, my lord, after having Mumbea was last seen in the custody of the police, and the state have not produced before this court any evidence to deny the fact that Mumbea was in their custody, my lord.
Their records don't support that assertion, so what else do you expect the state to produce? The state records, police records don't show that Mumbea was at the station, so what else is there for them to investigate?
My lord, it is our submission that the state, by failing to record Mumbea's threats in the in the police station's occurrence book, was in violation of the 5th schedule of the National Police Service Act, my lord, and they solely failed to record Mumbea's statements in the occurrence book with the intention, my lord. We, the petitioners, do suspect that the state has officers that are affiliated and are sympathetic to Kilina, and that's why.
Number one, it's an issue of evidence. What the state is referring to. Who has the legal burden of evidence?
Thank you, my lord. We, the petitioners, are the ones.
Legal burden.
Yes, my lord.
Show us the proof.
My lord. Thank you, my lord. My lord, we, the petitioners, do solely rely on the evidence that was presented by the 2 witnesses who were held together with Mumbea at Hongo Police Station.
That's all your evidence?
Yes, my lord. My lord, I proceed with the second link. Section 24 of the National Police Service Act.
Before you proceed, if the 2 witnesses are part and parcel of your evidence or what you rely on to make that assertion, do you mean that the police spokesman is a liar when he actually said that they have no record of Mumbea being in any police station? Mumbea was never in any police station. Mumbea never reported to any police station. No one knows where Mumbea is, number one. And number two, Mumbea having been in a habit of going into hiding. Can this be one of those circumstances where he's in hiding? And you want this court to issue orders in vain?
Thank you for those questions, my lord. First and foremost, the police spokesman is a person that engages in public human relations, my lord. And secondly, the state of Nadia, my lord, the state of Nadia has been on the UN watch list for extrajudicial killings and for enforced disappearance, my lord.
What is the property value of that report?
My lord, it has been submitted by jurists from the Amnesty International, my lord.
What is the property value of Amnesty reports? Amnesty International reports?
Thank you, my lord. We do submit that. First and foremost, my lord, that report was also reported by the United Nations, and the state of Nadia has ratified all.
You understand my question?
Yes, my lord.
Not what property value is.
Thank you, my lord.
What is property value?
My lord, property value is the relevance and the binding effect of that report before this court, my lord. My lord, therefore, the petitioners do submit that as much as this report is not binding on this court, my lord, that this court means before this court, my lord.
Okay, let me ask you. Do you want this court to disregard documentary evidence in terms of the OB?
Thank you very much, my lord, for that question. We do not plead that this court disregard the documentary evidence of the OB, my lord, but rather, my lord, to act in the favor of the petitioners and of the families that are related to the Mumbea, my lord, and in order to effect the right of Mumbea, my lord. We do pray that you hold.
Why shouldn't we consider the OB? You know, I'm not getting submissions around that.
Yes, my lord. My lord, the OB, we cannot rely on the police with regard to registering the threats of Mumbea in the station's occurrence book, my lord. Because in the first place, Mumbea went to Hongo Police Station, a station that is far away from Nabi, for failure of encountering officers that were affiliated or sympathetic to Kilina, my lord. This, my lord, establishes an intention of the police to fail to record Mumbea in the occurrence book of the state in order to protect their own, my lord.
Also, make a concluding statement.
My lord, I would like to briefly submit on issue number 2. The state has failed in its national obligation under Section 24 of the National Police Service Act by failing to conduct investigation, and likewise, it is in violation of Article 2 of the ICCPR, which mandates the state to always protect the rights provided thereby and to prepare effective redress in case of any human rights violations, my lord. In the fact, my lord, it is demonstrated that it is now a year after the killing of Tanjari and her 10-year-old brother, yet no conviction has been procured for what the state terms as lack of insufficient evidence. We, the petitioners, do submit before this court that the state indeed has primary or rather material evidence to convict this matter, basing on the fact that the ballistic examination of one of the bullets lodged in Tanjari's body matched that of the gun given to Kilina that particular day, my lord and my ladies.
One final question. What is the balance between the respect for human rights, the state's argument for balancing security, the state's argument of maintaining security, and human rights, the human rights for your clients? What is the balance? What's the test that you want the court to adopt?
Thank you, my lord, for that question. My lord, the petitioners do submit that denying human rights, denying people their rights is equal to denying them their humanity. Therefore, the state, in a bid to ensure that they secure national security, should come up with legislation to ensure that as they effect the national security of the state, they do not infringe upon the rights of the citizens of Nadia, my lord.
So that's the test.
What is the test?
My lord, we do pray that this court applies the proportionality test, my lord.
As defined by who? Is there comparative jurisprudence?
No, my lord, we do not have comparative jurisprudence, but we do pray that this court rely on the case of Ferdinand Waititu versus Attorney General, in which it was held that the court, in determining proportionality, should give regard to the necessity and the justifiability of the force used by the police, my lord.
So that's on a case-by-case basis?
No, my lord, it is not on a case-by-case basis, my lord. But we do pray that this court do consider putting human rights and national security on a scale in order to ensure that the two are balanced, my lord. My lord, 30 seconds to finish with our prayers.
Thank you very much. We will read your prayers in your written submissions.
Thank you, my lord.
The first counsel for the respondent is addressed to court.
If it may please this court, I'm Quinta Achemotino, first counsel for the respondent. My co-counsel is Kithenji Kizi Doreen. We will be responding to the issues brought forth by the petitioners, the first of which is whether the Nadian state actors violated the Constitution and international human rights law in quelling the protests. The same shall be handled by my co-counsel. The second issue before this court, which we have subdivided into two, the first bit being whether there was excessive use of force leading to the death of Tanjari and her brother. The same shall equally be handled by my co-counsel. And the second limb of the same, which is on the failure of the state to conclude investigation, which I shall handle. And the third issue before this court is on the enforced disappearance of Mumbai and Whelan, and whether the court can proceed to issue an order of habeas corpus in that regard. We intend to rely on the Constitution of Nadia, various statutes in Nadia, international treaties ratified by Nadia, and case law. We shall use 15 minutes each of the course time, and unless the bench directs otherwise, I beg to proceed to my submissions. Thank you, Your Honours. The respondents do not contest the jurisdiction of the court in this regard, as we are cognizant of Articles 23 and 165(3)(b) of the Constitution that gives the court jurisdiction to listen to the issues brought forth. Therefore, I would like to proceed to the third issue for determination before this court, on whether there was enforced disappearance of Mumbai and Whelan, and whether the court can issue an order of habeas corpus for the production of Mumbai before this court. Your Honours, counsel for the petitioners highlighted correctly, pursuant to Article 2 of the International Convention for the Protection of Persons Against Enforced Disappearance, as number 1, the elements being deprivation of liberty by the state or its actors, followed by refusal of the same and a concealment of the whereabouts of the individual. Your Honor, it is the respondent's submission that in this regard, the same has not been met. Your Honor, as regards Mumbai's case, It is a submission of the respondent pursuant to paragraph 19 of the fact sheet. In fact, the last sentence, which expressly states that the records at Hongo Police Station show no evidence of Mumbeya ever being booked there. Your Honor, the 5th schedule of the National Police Service Act, number 11A of 2011, expressly provides that in processes of arrest and detention, the officer shall enter particulars of the individual in a register. Your Honor, it is a submission of the respondent that there is no evidence of the same. Our records show no evidence of Mumbeya being booked there. Your Honor, further to that, pursuant to paragraph 18 of the fact sheet, in fact, the officer in the station informs Siki, Mumbeya's wife, that there was no records of the same in the occurrence book. She even proceeds to give Siki a tour of the holding cells. Your Honor, General Standing Orders 303 on the occurrence book provide that the occurrence book is a faithful and accurate record of all matters requiring the attention and investigation by the service. Therefore, if there was no mention of Mumbeya's allegations in the occurrence book, it simply follows he was not at Hongo Police Station to make that report.
So, maybe a clarification. Is there a legal requirement that for one to file for to make an application for a writ of habeas corpus, one of the requirements, a legal requirement, is that a record must be produced that this person was present at a police station during the occurrence. Is there a specific section of the law you can pinpoint this court to say that it makes it mandatory, or the 6th schedule only makes it a duty of the police to make sure that they record statements in the occurrence? Which one of the two is it?
Councillor, as you answer that, are those internal requirements of the police, or are they binding to the public?
Thank you for your question. In answering the first question put forth to me, I would like to rely on the case of Mariam Mohammed.
Before you go to the case, is there a specific provision of law which makes it an obligation or mandatory for a potential applicant to produce a record in the occurrence book if there is none at all? So you can't make an application if there is no mention of that occurrence. Is there a specific section of the law?
Thank you for your question, Your Honor.
Yes or no?
No, there is no specific section of the law. However, Your Honor, an order for habeas corpus can only suffice if the subject of that particular order is in the custody of the respondent. Your Honor, the order of habeas corpus, as was defined in the case of Mariam Mohammed versus the Attorney General and 2 others, 2007 before the High Court, hence persuasive before this court, it was stated that it is an order requiring the person who has detained another to produce them before the court in order for the legality of the detention to be determined. Your Honor, the requirement is that the person must have detained the other. Your Honor, our submission is that Mumbeya was not in our custody. Therefore, even if the court were to go ahead and issue a particular order of habeas corpus, it would be in vain for the simple reason that he was not in our custody. Now, Your Honor, proof of this is regards the records at Hongo Police Station. The only way to actually ascertain that indeed Mumbeya was held at Hongo Police Station is through the records therein. Your Honor, if the records show no proof of the same, it simply follows that he was not in our custody. Thank you for your question, Your Honor. The police officers.
So the public have no access to the occurrence.
Thank you for your question, Your Honor. However, it is a requirement that when one goes to make a claim to the police station, they have their records to be entered there.